From the most trusted names in local news, KDPG Sunday Edition.
Good morning and welcome to the KDPG Sunday Edition. I'm Megan Schiller. We are 2 days out from Election Day, and there is one question that voters across Pennsylvania will see on their ballots. It's known as Marsy's Law. The referendum will ask voters if there should be a new amendment to the Pennsylvania Constitution, providing rights to the victims of crimes. But in the week before Election Day, a court ruling brought some uncertainty. A Commonwealth Court judge issued an injunction barring the state from immediately counting or certifying the votes. However, voters will still see the question on the ballot, and it's possible that a new court ruling could make your votes count after all. So this morning we have three guests who can talk about what this all means. Valerie Dixon is the Director of Family and Community Support at the Center for Victims. She lost her son to homicide in 2001. Lori McDonald is President and CEO of the Center for Victims. She's been working in the victim services for 20 years and has written in favor of Marsy's Law. And Jacob Weiland is a criminal defense attorney as well as the head of Weiland Law Group. He opposes the amendment being added to the Pennsylvania Constitution. So thank you guys so much for being here and talking with me about this.
Thank you for having us.
So let's start off by talking about who is Marsy?
Valerie. Well, Marsy was a young lady who actually, there was someone that was arrested. They had a trial. He was found guilty. And she was not, she was murdered. Okay, that she was in a relationship. And it was domestic violence. She was murdered. When she was murdered, she had no idea that her assailant was released. So obviously he stalked her and he killed her. And so her brother was adamant about why wasn't she even notified about that. So he took it upon himself to try to find out, is there a law that we can make sure that victims are notified when their assailant or someone that is accused of harming them is released from jail? And then that way they can prepare safety measures for that.
What does Marsy's Law aim to do?
Well, Marsy's Law basically aims to level the playing field for defendants and for victims. Right now, the defendants, the accused, have a constitutional right to the First Amendment rights, as we all know, to fair trial and all that. But victims have only statutory rights, and statutory rights can be overturned and can be denied, so to speak, whereas constitutional rights cannot be. So all we're asking is that victims be afforded the same rights as those who are accused.
Is there a current law in place that gives victims rights?
There is. It's called the Pennsylvania Bill of Rights. And it ensures many of the same victims' rights that are in Marsy's Law, except that they're statutory, and through the passage of Marsy's Law, we hope to make them constitutional so victims' rights can be heard.
Can you guys talk a little bit about what exactly are the rights that would be added by adding Marsy's Law?
The same rights that are already in our Bill of Rights, the Pennsylvania Victims Bill of Rights. You know, we're required by law. This is part of why we exist, the Center for Victims, is because it's our duty and responsibility to ensure, as our law enforcement, everybody else, that the victims know what their rights are in Pennsylvania and that their rights are not denied. But as statutory rights, they can be denied.
And we put up on the screen some of those rights, such as to be notified of legal proceedings,
right,
to speak during trials and parole hearings, right to demand speedy trials, as well as right to refuse requests for pretrial evidence and right to receive restitution.
Right, and that's why during the trials, that's why we want victims to be able to be heard, because sometimes a judge can say, no, we're done. If a victim says, oh, I want to say something, and the judge can say, no, we're done.
So there are many groups, including some prominent groups like the ACLU, who have come out and said that they don't like the amendment in its current form, or they take issue with it. Can you explain that side of the argument?
Absolutely. So you begin with the proposition that our Constitution provides the basic framework for our system of government and fundamental rights that protect us all from governmental overreach. Press, assembly, freedom from unreasonable searches and seizures. It does not and was not intended to provide laws or protections between individual groups of citizens. So, you know, my first concern regarding Marsy's Law is its form, in that I don't believe that it belongs in the Constitution. Second, Marsy's Law provides, as has been described, a whole list of rights and protections for victims, which, at its core, I have no issue with. I believe it's right and it's appropriate that the victims of crimes be provided with notice and be provided with reasonable protection, and be provided with access to restitution, and be provided that their voice be heard. The question is, where do those protections belong? Does it belong in the Constitution, or does it belong in a statute? By providing these constitutional rights, essentially somebody that comes forward and alleges that they have been the victim of a crime, just by making that allegation, shrouds themselves in these laundry list of constitutional protections. By being shrouded with those constitutional protections, that's a legal determination. And by inference, because they are now constitutionally determined to be the victim of a crime, necessarily the other party is constitutionally determined to be responsible for that crime. And that's inconsistent with one of the most fundamental bedrock principles of our criminal justice system, and that is that the accused is innocent until proven guilty.
What about the rules when it comes to adding an amendment to the Constitution? As someone who's not a lawyer, you might read that and think, oh, that all sounds fine, but apparently it is addressing different sections in the Constitution, and that's one of the main arguments that they say is not allowed.
Sure. I mean, as I understand, the challenge that was raised by the ACLU and the League of Women Voters addresses exactly that because it's such a long list of changes to the Constitution, as I understand it's 15 different changes to 8 sections of the Constitution, that the argument is that each of those should individually have been considered and voted on.
So this week, though, and before I let you answer that, this week the judge ruled something that probably upset you.
Absolutely.
The judge's ruling said if passed, Marsy's law would have immediate, profound, and in some instances irreversible consequences on the constitutional rights of the accused and in the criminal justice system. So that's a setback. What did you think when that came down?
I want to address what Jacob has said here too, is that he's referring to the Constitution of the United States of America. I get that. This is a constitution to Pennsylvania's. This is an amendment to Pennsylvania's Constitution. At any rate, and so this comes at the 11th hour. This bill has been through the legislature for 2 sessions. It was passed unanimously in the Senate and unanimously in the House. The governor, the attorney general, the Fraternity Order of Police, they all support this.
Why do you
As
think
a matter
people
of
don't
fact,
support it?
Let me finish though, but 35 states have already passed this and made it part of the Constitution. And, I'm sure that that Jacob here is I'm sorry, I forgot your last name.
Sure.
Mr. Weiland is a very good attorney, and I know that he's also aware of what is called the single subject law, and that is what this judge is referring to. What the ACLU and the League of Women Voters has done is they brought up this issue at the last minute, and they're trying to determine that there are many different parts of this, when in fact a constitutional amendment is only allowed to happen if it's been determined to be a single subject, which this is. This is about victims' rights, and that's it. Everything that comes before the constitutional amendment has to be vetted ahead of time, which this has. And it met the single subject rule, and that's why the legislature voted on it.
So to specifically respond to one of the issues that you just raised, the distinction between the federal versus state constitution, the rights that I briefly listed that protect us against governmental overreach, they exist in parallel in most cases, both in the federal Constitution and the Pennsylvania Constitution. So the concerns that I have are specifically related to the Pennsylvania Constitution and how this amendment would affect those rights. And in addition to the general concerns I have about the architecture of it, I have specific concerns about some of the rights that are provided for. Number one, that the person who alleges to be the victim of a crime would have the ability to refuse to provide pretrial discovery, and number two, that they would have the right to assert a constitutional right to prevent the case from being delayed. So as a defense attorney or somebody who's endeavoring to protect somebody else, it's important for me to be able to fully investigate that. And if an individual can assert a constitutional right to stand in the way of that and provide, I don't have to share this information with you, or if I need more time for an expert witness to review a case or to seek a witness, and I ask the court for that, then there's a third party that can stand in the way and object to that continuance. And it's not hard to imagine if you have a circumstance where there's incomplete information, there's an incomplete investigation, and there's a rush to trial, that we could run into a situation where innocent people will be convicted of crimes as a result of that.
I just think that's
incorrect.
just a real, far stretch. I'm not, privy on the legal jargon of all of it.
You've
I have
experienced this.
experienced, not only I, but thousands of cases that I've had in the 18 years that I've worked for the Center for Victims. And I know that defense attorneys, I know that those that are accused, they have all the rights in a courtroom. It's mentioned a million times while I'm in court. Why don't I have a right? Why can't I say anything? How come what we say is outside the courtroom, but it's not on the record? So victims are truly, truly impacted by not being able to have a right. Now, we have, as was mentioned, the Victims Bill of Rights, but it's just a Bill of Rights. And so if something happens and someone's not released or someone's not notified of a motion or something that's coming up, and no one's really held accountable. I mean, it's like, oh, I'm sorry, we didn't get in touch with you, but this is what the judge decided. And you're still victimized once again. So the trauma that's left behind, just because you have a voice now, it's up to a jury of your peers or the judge to make the decision at the end. So the victim is just only asking for some input on how the crime has impacted them. This is a commonwealth. And so if we're all to be held common in this process, then we should have an opportunity to speak. Victims don't even really get a chance to speak. They're just spectators in the courtroom. They're spectators in the courtroom, and unless they are on stand or a family member of a crime, I usually deal with homicides. So the deceased has no voice. So if the family member cannot say anything, I mean, it's really, they're just spectators in a courtroom, and they get to see everybody else say what they need to say with no input, and they're the ones that's truly impacted.
I've worked as a prosecutor and as a defense attorney in multiple jurisdictions across Pennsylvania. And in the thousands of cases that I've handled, consistently, the judges that are overseeing the cases, the district attorney's offices that are prosecuting the cases, the police officers that are investigating the cases, they take the rights and the voices and the input of victims very, very seriously. I can't think of a single instance where a judge or a prosecutor's office doesn't take these rights seriously, doesn't give them a voice. Now, that's not to say that the system isn't perfect and that there might be mistakes or things that can be changed or improved. And I support a majority of the things that are listed in Marcy's Law about the right to access and the right to be notified and the right to have a voice in this process. But I believe that those rights are more properly enshrined in statute rather than Constitution for exactly the reason that we're disagreeing today, is that as the court considers these questions on discovery or on the ability to stand in the way of things, if it's determined that something needs to be fixed or corrected within this laundry list of protections, to do so, if it's in the Constitution, would require further constitutional amendment. Whereas if it was in the statute, it's more easily remedied. Not everything that's worth governing is worthy of being placed in the Constitution.
Look, this argument has been the basis for Marcy's Law started several years ago. It's been upheld, and 35 states have made it part of their constitution. The ACLU, the League of Women Voters, who professes to teach people about policies and help them educate them about, it's not even on their website. I have no idea why the League of Women Voters is involved in a last-minute attempt to stop a victims' rights law. It's not on their website, not national, not state, not local.
What do you want voters
so here
to
we
know
are at the
before they
I
go?
want voters to know that this law has been well thought out. It's been passed by both sides of the legislature, back and forth, Senate, House, the governor, everybody, 35 other states. There's absolutely not one piece, not one shred of case law that shows that the defendant's rights have been, altered or,
A response?
Well,
briefly?
there is active litigation in South Dakota in particular on exactly these issues.
It's not on the defendant's. No, that's not correct. This law has not been challenged because a defendant has had their rights violated.
The rights that are enshrined in the Bill of Rights are designed to protect the individual citizen against government overreach. It's not intended
I agree with you.
to litigate disparities and disputes between individual citizens. When the government and all of its weight and resources turns its attention to prosecute an individual and to potentially take away your life, your liberty, or your livelihood, it's imperative that the protections that exist continue unimpeded. And unfortunately, this law in this form would damage those protections. And again, I don't object to the things that they're outlining. As you know, I worked as a prosecutor for years.
Just don't like it in this form.
It's in this form. in the Constitution
It's
is
so
the
sad that we have
concern.
to wrap up.
Where-
Obviously, there's
may
so
I-
much that we can talk about.
It is.
You know-
I would just like for people to just go and vote. Just vote for it and let them, iron it out. But if you really
Whether it's
believe that
counted now
victims'
or
rights
later, still-
should have a little more enhancement in the process, please just go to the polls and vote.
All right, thank you so much, guys, for being
Thank
here and
you.
talking with us. So coming up, a bus through a sinkhole. It's all anyone was talking about this week, but it has put our city's infrastructure issues into stark relief. So how can we address them? That's coming up when the KDPG Sunday edition continues.